Hi, good afternoon, Dash. How are you?
I'm fine, Tila. Nice to hear from you too.
Yeah, it's
Hope
been
you're
some
fine.
time since we sort of chatted.
Yeah,
Um, so we are here back again, talking about some topics of interest where I see, a lot of questions has been brought up. So I was wondering whether we can, ask your expertise today on some of the queries that I actually have.
sure, ahead.
Okay. So I think one of the question is which I see quite norm that a lot of people are asking, and I think I just want to also get some clarity as well. Okay.
Sure.
When we are doing a disciplinary process, do we really have to follow like show cause, DI warning and all that? Maybe you can just give your overview.
All right. Disciplinary process. Yeah, we have to understand what we are addressing first. Is it a misconduct, poor performance, whatever it is? Okay, we'll take it from the point of a misconduct. For example, if an employee steals from the employer, this is a misconduct which the employer has now to deal with. What can the employer do? Okay, the employer can first issue a show cause letter. In the show cause letter, you must give reasonable time for them to explain. Okay, and in that show cause letter, you must give adequate details. For example, the charge, the date, the time, the place. What is the details of the offense? Okay, we need to make sure that it's addressed fully in the said show cause letter, and then thereafter they have to reply to that said show cause letter within how many days the company wants. Usually company gives about 7 days or 14 days. I've seen some companies give 2 to 3 days reply. I mean, for me, that's not reasonable, but it's still acceptable. Now, after receiving the reply, the company has two choices, which is to either conduct a domestic inquiry or issue a punishment according to the reply received. Now, why are they two choices? Because the domestic inquiry is not required under law. Okay, many people says that it's required under law, Section 14 of the Employment Act. But if you read closely, it says due inquiry instead of domestic inquiry. Due inquiry is basically you giving them a chance to explain, which is the show cause letter. So once that has been given, you have satisfied Section 14. And some of the instance where you do not give a domestic inquiry, the courts has already said it is not a nullity. It does not nullify the dismissal, does not make the dismissal wrong, because the courts will rehear the matter again. So domestic inquiry is not really necessary, but for procedural fairness, you can do a domestic inquiry. It's just the same thing over again. A mini court process where you give them the charges, you get a prosecutor to prosecute them, you get them to explain, and then the panel decides on the charges. And after that, you mete out the punishment. Now, the punishment here, it can be a warning letter or it can be whatever, dismissal. According to the company's own disciplinary handbook, usually some would give warning letters, some will give dismissals, some will give unpaid, suspend without pay. It really depends on the company themselves. Whether all is proportionate or not, it really depends on the facts. Okay. Some might be legal, some might not be legal. It really depends on the facts. So I have to emphasize it. So honestly, it's a really simple disciplinary process, i.e. show cause letter, get a reply, mete out the warning. Now, what if you have a very severe offense, criminal breach of trust? For example, stealing money and then using the company's information to cheat them. Okay, that's a very heavy offense. Now, would I advise to deal with it through show cause letter? I would say no. It best be done through a DI. So it really depends on how you see the offense, whether it's serious or not. Okay, I hope that answers your question on.
Yeah, thank you. We covered misconduct, we covered CBT. How about performance issues? I mean, performance matters. We have obviously a lot of companies have PIP, performance improvement plan, but yeah, maybe you can elaborate on that one.
Okay, per performance issues, we have to look at it from two perspectives, which is either before probation and after confirmation. Okay, if it's before probation, the company has this clause in their contracts that they can extend your probation period. Okay, after the probation period, then we can terminate you. That's a very easy way to deal with it. But after you're confirmed, now it gets slightly harder because the company has acknowledged that you have been performing and you have met the minimum standards to be a confirmed employee. So what do we do then? We do few things, which is to, whenever there is a issue of per performance, usually a KPI issue, okay? Very mostly for SMEs and MNCs, they will have these KPIs, okay? This would be quarterly or mid-year. Okay, quarterly, if they fail to meet the KPIs, they will have a warning session or counseling session, which is by right the proper way to be done. Okay, so every time a per performance issues comes up, just have a written warning, no verbal warning. Okay, it must be written.
Okay.
Or have a counseling session which is recorded. Either one. So the employee knows that the company is taking actions to notify them of their performance and asking them to get better. Now, this can be done up to 3 times. You can do it. I suggest to do it up to 3 times. Basically, have these warnings given to them regarding the performance up to 3 times. Why 3 times? To me, it's just a magic number. It's not really anything. But it's just giving them some proper notice, reasonable notice. Okay.
Yeah.
So after the 3 times, then you do, if they're still not performing, you do not need to put them under a PIP. You can straight away dismiss them. Okay, because they are not meeting the company standards and they're just wasting companies' resources. But some companies, they have a bigger heart. They are magnanimous, so they put them onto the PIP program, asking them, this 6 months, you have to meet these certain standards if you want to be retained. If not, you're dismissed. So again, it's a very simple process. It's not really that complicated. You just need to warn them, make sure you warn them every step of the way, and then take the appropriate punishment. Okay. And PIP, again, is not necessary. Same thing like domestic inquiry. It's not really necessary in law.
Okay, thank you so much. And I have one more final question to ask, and this is, I think, one of the famous questions. When you're doing a DI, what is important? Whether do we still need a panel of 3, panel of 2? So maybe you can sort of give us more clarity on that, because I think people have different ideas or sometimes don't have a clue. So maybe you can share a little bit about the process of DI, who are the parties and everything.
Okay. DI is made up of 3 main parties, which is the panel, the prosecutor, and also the accused. Okay, the accused is the employee, the prosecutor is the one charging the offences against the employee. The panel is the one going to decide whether they have made out the said charges and whether the employee is guilty or not. Okay, so the question here is whether how many people do we need for the panel? It's recommended to have 3 because 2, you'll always have it might be 50-50, so that there'll never be a proper decision. 1 definitely not necessary. 1 is not even recommended at all. Okay, so it's 3 is always recommended. Now, for small companies, how do they meet these requirements? Definitely cannot. Usually, for a small company is made up of your mother, brother, sister, or like that, or just 5 employees. Usually all of the same rank, same experience. So how can you deal with them? The panel members must be either someone not connected to the employee or someone of a higher rank. Okay, so these are all requirements for the panel. It's actually more than that. I'm just trying to summarize as much as I can.
Thank you.
Now, the prosecuting officer is usually someone from the company. It can be, honestly, it's usually the HR or the IR manager, whoever it is. They will just bring the charges against the employee, and the employee has to defend. So the procedure is the charges will be read out by the prosecutor. The employee will plead guilty, not guilty. If not guilty, the prosecutor will then lead evidence to prove those said charges. then the employee has a chance to rebut them, bring in their own evidence. If they have pleaded guilty or they are found guilty by the panel has to make a recommendation on the type of punishment. Okay, they just make a recommendation, they do not decide. Okay, the panel will decide, okay, dismissal is appropriate here, then the company has to take that decision whether they want to dismiss or not. So they can either they can do whatever they want based on the information given by the domestic inquiry. Domestic inquiry found them to be guilty and punishment is warranted. The company can then say, okay, you've been found guilty, however, we're going to give you a severe warning. That can be done. It really can be done. I have an instance where I have a case where the employee was charged for cheating. Okay. The panel, he admitted guilty also. Okay. Panel found him not guilty, despite him admitting he was guilty. It's a very weird situation. There was no recommendation because he was not found guilty, but the company decided to dismiss them. Okay. The case was lost at the industrial court by the company because the panel found otherwise. And there was the cheating offense is just basically he had wrongly claimed 70 ringgit.
Okay.
Okay, he had wrongly claimed 70 ringgit, which he said it was part of his medical plan. But the receipt came to show it was his wife who claimed the 70 ringgit.
Right.
So company decided that's cheating, fired him. It went to the High Court. High Court upheld the industrial court's decision and said it is the award breach was appropriate and upheld it. And it went to the Court Appeal and Court Appeal saying no, it is the industrial court and the High Court had wrongly erred in law because cheating is still cheating. There's all the evidence has shown.
Okay.
So it can be the recommendation of the panel is not final. Decision still lies with the company after all evidence has been adduced.
Right.
Okay.
All right. Thank you so much, Dash.
No
I think
worries.
I definitely would say that this is going to be a beneficial video for everyone. So watch out, everyone. We talked about show cause, we talked about DI, all these are hot topics. So thank you, Dash.
No
Thank you
worries.
so
Thank
much.
you.
Take care. Bye.
You too. Bye-bye.